Now, I'll tell you what I find morally offensive. The continuing atrocious embarrassment of the Connecticut court in the Alex Jones trial.
Robert, while you go on, let me at the very least pull up a white pill to all of this, but please go. It's over. I mean, it's over the top, but what's your take on the latest?
So, I mean, what we witnessed all week was a complete disgrace of a trial. It is a pure show trial that is a mockery of civil justice in America, that is made to look like a trial on the merits, when in fact it is not a trial on the merits, which makes to just demonize Alex Jones by allowing any evidence that's adverse to him to be presented, but none of his defenses to be presented, all in the guise of a damages trial that has had almost nothing to do so far with actual damages suffered. And that's because, as was admitted by multiple people, but starting with by the plaintiff's counsel implicitly, and then by the primary plaintiff they put up, in fact, people are suing him who never heard him talk about them ever. They're suing him under consumer fraud theories and other theories that make a joke out of Connecticut's laws. And what you're also seeing is a judge who was so ready for this show trial for her little Broadway performance. The Phantom of the Opera is shutting down in Broadway, but apparently it's not shutting down in the Connecticut courthouse in Watertown. The judge, and to his great credit, if you want to expose a show trial for what it is, if you want to advocate without limit, but outside of sticking within your ethical professional obligations, there's been no better example throughout the week by Norm Pattis, who has been able to stand up to this corrupt rogue judge who makes a disgrace of the Connecticut judicial system and of American civil justice, and who's getting increasingly enraged at his willingness to challenge and contest and question her illicit actions to make this show trial anything other than what it is, a travesty of justice in America.
Robert, you're gonna have to explain the nuances here. I think I understand even the nuances, but it's terminology that I'm not familiar with. People, you have to watch this clip. This was after an objection, and the judge said, "I'm sustaining the objection," which was raised by plaintiff's counsel. And then Norm Pattis says, "Can I have a legal basis for it?" And then the judicial hilarity ensues. Listen to this.
I think we're ready for the jury.
My record needs to be complete, Judge. The basis for upholding that objection is?
We're ready for the jury.
That's not a legal basis, Judge. May I have a ruling that the appellate court can understand?
There was an objection, and I sustained the objection.
There was no legal basis stated. I'm entitled to that under the practice book, and you should deny the motion on that grounds alone. It's insufficient for somebody to stand up. They're supposed to provide me with notice so that I can respond.
I believe that he argued it for 20 minutes, and I think the record is clear, Attorney Pattis.
He said hearsay, but it can't
be.
And
if it's not clear, wouldn't be the first time, and you'll move for an articulation, and I'll articulate when I'm directed to by the appellate court. I understand that there will be an appeal. I assume
maybe
there
not.
will be.
We might win.
There may be an appeal. There may not be an appeal then, but I assume there will be an appeal.
Robert, when he says I'm entitled, first of all, I mean, what do you think of that?
So what you're seeing throughout the trial is a lawyer just standing up and saying objection and citing no grounds whatsoever. Objection, objection. And the judge going, sustained, sustained, sustained. This judge makes the judge in Idiocracy look like a beacon of intelligence and integrity. That's how bad this judge is. So that's what I've told people. You can just watch any little piece of this trial and realize that what a complete sham it is. Again, you don't have to be a fan of Alex Jones to recognize that this is a disgrace, that they're using him to establish that they can run American show trials, that they can strip people of their civil rights and civil liberties, their rights to the rules of evidence, the rights to the rules of due process, the rights to trial by jury, in order to take away his right to free speech, freedom of press, and freedom of association, in order so that he cannot be an advocate about your Second Amendment right of self-defense. They're trying to strip them all, and they've done it throughout the case. They violated his Fourth Amendment rights to privacy in multiple contexts. But just this little illustration is a judge who, for young lawyers or people out there watching this, I've heard from random law students saying, what in the world is this? We're taught in first-year law school that you can't just say, objection, I object. You have to say objection and cite either the rule or the evidentiary standard related to it. So you say, I like to cite the rule because it avoids getting into a public discussion in front of the jury of the underlying content, which you're not supposed to do speaking objections of that type, where you're trying to educate the jury and testify to them through the guise of an objection. But what you're supposed to do is say objection, or if you don't want to cite the rule, hearsay, relevance, unfair prejudice, lay testimony, whatever the grounds may be. And what's happening is they're not doing that. They're just saying objection, sustained, objection, sustained, objection, sustained, because she's such a robot up there and so obviously prejudiced. I mean, even people that are anti-Alex Jones, like Uncivil Law and some others, have recognized that this court's behavior is beyond the pale. Nobody can watch this court's behavior and say, that's a beacon of integrity. That's a sign of impartiality. That's the kind of judge I would want in my case. Nobody can say that. And it gets worse every single day, screaming at him about whether he stands up in a certain way when he makes an objection. So he has to stand up in a certain way before he can make an objection. But the other side doesn't even have to cite the legal grounds ever for their objection. That's what a crock of a trial this is. We did a big, long special edition on Thursday. I recommend that for the more full, robust understanding of this case, its context, its broader social, political consequence, and other attributes of this case. But I wanted to highlight that example because that example is it's illustrative. You can tune into this trial and you can't watch it for more than an hour on any day without seeing evidence that doesn't appear to have any relevance to the proceeding, and a judge that not only doesn't have the temperament to be a judge, but is so overtly and openly prejudiced and bigoted and partisan that it's a disgrace to witness. While the white pill part of it is you have a lawyer like Norm Pattis, not a fan of Alex Jones, comes from the left, lifelong Democrat, but who knows his job and cares about his constitutional role, and he refuses to allow this corrupt hack of a judge harlot our core and key legal and constitutional principles for the political aims and objectives that she seeks. So great credit to Norm Pattis for continuing effective advocacy. If you want to watch how you can stay a strong advocate in difficult circumstances with a rogue judge, you can see no better example than watching how Norm Pattis has handled himself in this trial.
Yeah, I'll play this one because this is also on point.
What I'm trying to do is defend Alex Jones and his contention. The contention I told the jury, he's an angry populist who, as Mr. Maddie has said to several witnesses, believes there's a global conspiracy to enslave people. It may not be a belief you or I share, but you can't use a CUTPA statute to silence a person for unpopular speech. And that's what they're trying to do here. What I'm trying to do.
It's phenomenal. I mean, he's doing it in a way that I think most people are unable to do, myself included. Like, you'd get too frustrated, you'd lash out, and you'd give exactly what the judge wants you to do to reprimand you. But when he said, by the way, to the judge, I'm entitled to notice. Notice in that context means the basis of the objection for the purposes of an appeal, correct?
It's both. It's, in other words, if somebody says objection, that tells me nothing. How am I supposed to say there's nothing objectionable in my question if I don't know what the grounds of their objection is? So I need to know what their evidentiary ground, what rule is it, and how does it apply in this context? And so the fact that she's allowing these objections just without any even citing, like in this case, they end up discussing it a little bit longer, and by implication, it was hearsay. But what she's doing on a regular basis is allowing them to just say objection without saying what it is. They're not just saying what it is. And it's so she can doctor the record later and create a bogus basis for why she sustained an objection that they didn't actually timely and correctly make, that he was deprived of his opportunity to meaningfully and timely respond to because they didn't make the basis of it at the time. If I did this, I would be in contempt and in jail if I was doing what the disgraced hack political plaintiff's lawyer was doing in this case, this former U.S. attorney. Tells you the quality of former U.S. attorneys, by the way. I mean, other people have watched this, and they're like, this guy's not even a good lawyer. He's not skilled. He bores people. He repeats dumb points. He's an angry, contumacious personality. But if you read the press, they'll celebrate him, demonize Pattis, and worship the judge. Like Law and Crime, which has been kind of a joke increasingly of a publication. I helped put Law and Crime on the map. Dan Abrams owns it. I'm a big fan of Rachel Stockman, who's one of the editors-in-chief. They got too many lefty hacks over there. Yeah, at least try to be kind of impartial when you do these presentations. Don't just play to the wokesters. That's not a lifelong. How did that work out for you, Dan Abrams? How did that work out for your little police show when you tried to play to the wokesters? You got your show removed and now you have to sue them to get back your money. Maybe someday they'll figure this out. But you're not getting any honest, independent legal analysis. You have people like Elizabeth Williamson, total hack. For the New York Times, disgrace of a human being, disgrace of a writer. The people are going to these people to try to get information, and they're getting unreliable, misleading information, a lot like they got in the Johnny Depp trial. There they saw as like, this goes beyond ordinary politics. This goes, they pick winners and losers, and they shape the facts. So when you watch this case, you can see what a show trial is. To show trial inside the court, to show trial outside the court. And credit to Norm Pattis, who's the only one who refuses to play his part in such a show trial.
Yeah, it's amazing. One last question for my own benefit, Robert. When the judge said, if I'm ordered by the Court of Appeal for, what was the word? It wasn't clarification. It wasn't direct. Was it directives? She used the term.
What she's basically admitting is what she's up to. It's a corruption of the principle, which is let somebody make an objection without stating their basis. And then later on, if the Court of Appeals said I erred in the process, I'll make up a basis then. Okay, I'll figure out what the basis might be, could have been, right? And that's what you're doing. So you're not allowed to do that in the legal system. But apparently you can in Connecticut, or at least with this judge.